9:30. Yeah, other than that, we're okay.
Okay, we're going on the record on cause number DC 205795, Casey versus Mira Skandari. Counsel, make your appearances.
Brandon Fuqua on behalf of plaintiff, Your Honor.
Craig Capio on behalf of Mr. Amir Marish Kandari.
Lloyd Kelly on behalf of Jack Nichols, a lawyer, non-party.
All right, we're on the my court reporter is at a doctor's appointment right now, and the parties have agreed that if need be, that she can transcribe this hearing from YouTube. This is currently being broadcast onto YouTube. Is that correct?
Yes, Your Honor.
Yes, Your Honor.
Okay. So it's clear, we're resetting the show cause hearing to next Tuesday. We've had a lot of scheduling issues, and there's certain agreements that we're trying to make. So Mr. Kelly, who are the witnesses that you wanted to see if the subpoenas were going to still be good for?
Casey and Schmidt, I believe one of them is the plaintiff itself.
Let's do these one at a time, Mr. Kelly.
Casey.
Casey. Okay, is that agreed, Mr. Proctor? I assume that's agreed to.
Yes, Your Honor.
Second one.
Schmidt.
Is that agreed to, Mr. Proctor?
I'm sorry, Your Honor. I don't know who Schmidt is, and I would ask if that subpoena has been issued and when it was issued.
We have been trying to serve him, and then every time the thing got Donald Schmidt, we have not been able to find him.
If you haven't served him, then that's your problem, in my opinion. I mean, if you've served him already and you want to reset it, but if you haven't served him, we moved this to accommodate Mr. Mira Skandari. We're not gonna allow, you know, if you haven't been able to serve him, that's not fair to Mr. Proctor that we're producing. Mr. Kelly, do you agree?
No, sir. I think that we have tried to serve him, and we should have enough time.
Then we're going forward with this hearing later today. Then, if you can't, that is a completely unrealistic and unfair position. So, once we get my court reporter, we're going forward with the hearing today. Everybody needs to appear in person.
Yes, Your Honor.
In Dallas?
Yes.
I'm in Houston. You said we could appear by Zoom. I don't know how I can get to Dallas.
I'll give you until 2 o'clock today if you're going to be that unreasonable.
And Mr. Mira Kandowski is in what is it, Iran?
Everybody's trying to be reasonable here. You're being completely unreasonable, Mr. Kelly. If you're going to be completely unreasonable, I'm going to make. It's not fair to Mr. Proctor that you're trying to get him to produce somebody that you can't even find and he doesn't know who he is.
Well, then we could cross that bridge when we get to it if I need him and we have to have a continuance of the hearing. I don't have a problem with that. I've also offered the 8th, the 15th, and the 22nd as dates that were available, which time I would go. But I have to have a date to serve somebody, and we have been attempting on the prior dates. So
this hearing was set for today. You didn't have them set by today. I agreed to move it for Mr. Mira Skandari. I thought we all were going to be fair about this, and I agreed to reset it. But Mr. Kelly, you can't expect Mr. Proctor to produce somebody who he doesn't know who he is, and you can't find. That's not fair.
I'm sorry, Judge. We're on a different page. Then let me restate this: if the plaintiff doesn't have control over Schmidt, I understand that. I'm not holding him to produce somebody he doesn't have control over. However, if I get in a hearing for contempt and I need this witness, I would reserve the right to come to you and ask for a reset or a continuation of the hearing until we at least have another attempt to get him under subpoena. We will continue to try.
You're using Mr. Mira Skandari's death of his father to try to reshuffle the deck here. In my opinion, this was supposed to go forward today. I thought we all agreed that this was going to be a situation where we're all going to be humans here and not try to use his father's death as some kind of tactic to extend things. And that's what I feel like you're doing, Mr. Kelly. We were supposed to go forward today. You should have had him served by today.
Your Honor, last week you were clear on the record. We were not going forward with the contempt today. I asked that question specifically. And I said, do I have to appear in person?
And you never brought this issue up when I did that.
Nor
was
did
never brought
anybody
up.
else about whether we had to have subpoenas for today. And I think I would have time to get him by March the 8th or the 15th or the 22nd. But I've just alerted you to what is a procedural issue. I can show up today, but then I still have the same problems. But the 27th is very short notice. I didn't object. I'm saying I can be there. He's going to have Casey there.
It's not short notice. The hearing was supposed to be set today, and we agreed to reset it we reset this hearing over and over and over again because of Mr. Mayor Scandari and his father's situation. We actually have a date that we can all do, and now you're trying to use an issue that you've never brought up before to try to derail the hearing.
I don't think I'm trying to derail it, Judge. I'm trying to work with you.
You're not trying to work with me at all. You are not trying to work with me. You're trying to use this as a tactic, in my opinion. So this is, Mr. Facua, what do you want to do on this? Do you want to go forward today, or do you want to reset this to Tuesday?
Your Honor, I defer to the court on that. I will just note the history here is exactly how your Honor has put it out. Your Honor signed a show cause order September 13th. We've reset that now 4 times, all at the contemnor's request. Today is
Mr. Facua, let me just ask you this, Mr. Facua. Has Mr. Kelly at any of these resets ever brought up the issue about these subpoenas?
Never, Your Honor.
And now he's bringing it up for the first time.
That's correct, Your Honor.
Mr. Kelly, I'm really trying to be reasonable here.
What would you like me to do, Judge? I'll be there today. I'll be there on Tuesday. If Mr. Casey's the only witness I get, I just would advise you that if there's an issue where Schmidt could testify and bring some information at that point in time, I'm not saying I need him today. I don't know what the plaintiff's case in chief is, but if you get there, I would then reserve the right to request for you to give me additional time to get this witness. Otherwise, I'll go forward as you require me. But these are two. My client, Mr. Nichols, has never once asked for continuance. These have been legislative continuances by statute. And then once on the death of somebody's father, Mira Kandusky. My client was ready to go then and ready to present issues regarding these subpoenas with Casey and Schmidt. We have been actively trying to serve them, but that requires a date certain, or you can put in the order.
But Mr. Kelly, if this has been such an issue, why haven't you brought it up before today? Why didn't you obtain some kind of substituted service, request of substituted service? Why are you just bringing this up now? After all of these resets and all of these hearings?
My research shows you can't substitute serve as a witness who's a non-party. My understanding was Casey and Schmidt have some relationship. I'll check on that. I thought the plaintiff was in contact with them. But I could be mistaken by the plaintiff's answers today.
All right.
I'll be there today. I'll be there on Tuesday. Whatever you want, Judge.
And your client's available today?
I guess he is. We'll jump a plane. I'm also in the middle of a depot, but I'll go in and cancel it.
We're going to move this. We'll move it to Tuesday. I am not happy at all with this kind of tactic. I will say that, Mr. Kelly. But let's keep moving. Let's go. What else? What are the other witnesses?
That's it.
We don't have any, Your Honor, because the contemnors will be present in court and don't require a subpoena. On plaintiff's side, we've not subpoenaed anyone. We don't intend to subpoena anyone.
Capua?
No witness issues, Your Honor.
All right. I do expect Mr. Casey and Mr. Kelly's client, everyone needs to be in person for this hearing. No one is allowed to be remote. All right, guys, we will see you next Tuesday. And I assume everybody, we've already talked about this off the record, everybody agrees that Mr. Facua doesn't have to, he's going to reissue a notice. No one's going to object to that for purposes of notice. He can reissue this for Tuesday, correct? That's the date we agreed on.
Correct.
Yes,
Your
sir.
Honor.
All right.
That's correct, Your Honor.
Before
All
we go,
right.
Your Honor, I want to be clear. So are we reporting here at 9 a.m. or
You're
we're calling in at 9 a.m.?
We're reporting here in person at 9 a.m. and then I understand Mr. West has to go to a hearing, so we're gonna figure out a time during the day on Tuesday to hear this.
And it's possible that hearing might get settled, so we'll try. I just want to let the court know.
Okay, we just make sure that somebody is here at Tuesday on
Tuesday at 9 a.m.
Tuesday
Yes,
night.
sir.
All right, thank you, guys. You have a great rest of your day.
Thank you, Your
And Rhonda, make sure to put that show cause on the docket for next Tuesday.
At 9 o'clock, right? Or 10?
9 o'clock.
And Your Honor, would you like me to submit a proposed order on that show cause, just resetting it?
Yes,
Thank you, Your Honor.
and get that to me as soon as possible so I can sign it.
Yes, Your Honor.
All right, thank you.
Thank you. Bye-bye.
Email it to Rhonda.
Yes, Your Honor.
All right, next case is Big Shoe Auto Sale versus Tucker. Is there anyone here on that case? Mr. Wallace, are you here for that?
Good morning, Your Honor. Yes, sir, I am.
You'd wanted an emergency hearing on this, so we got that set for you. All right, let me pull this up. So go ahead and, as I mentioned, I don't usually have hearings for this, but you wanted a hearing. So what is the issue on this one that you wanted to discuss with me?
Well, Your Honor, thank you for setting this up. Thank you, Rhonda, for helping us set this up. What happened was my client is a vehicle dealer in Irving. The timeline is my client sold a, let's see, it is a 2020 Hyundai Elantra to defendant Fred Tucker in April of 2023. Mr. Tucker was involved in a collision in June of 2023 and brought it into defendant Dub House in Dallas County. It's our understanding, Your Honor, that Dub House did not verify any insurance information, did not kind of get any pre-approval or anything that's fairly standard in the industry from Mr. Tucker or Mr. Tucker's insurance company. Did some repairs, and then Mr. Tucker has since basically ghosted Dub House, has not picked up the vehicle, and therefore that's another issue for later on in this case, basically accelerating the payments due along with replevin of the vehicle for my client.
I've handled hundreds of these types of motions. I will say that now that I look at this, I've never seen anyone do it this way. Your writ of sequestration order is unlike any I've ever seen. It doesn't have a lot of I've never seen one like this at all, actually. It doesn't have the amount of replevy bond. Your client usually has to post a replevy bond or post a bond. Doesn't have any of that information. So the order is just, it's usually a 3-page order. This is a quarter of a page, so I don't know where you got this form from, but you need to give me a new form that indicates that includes all the standard information in there, especially the amount of your bond and the amount of their bond. So
Yes, Your Honor, I'd be happy to refile a new proposed order to that effect. I think we would just need the court's assistance in determining the amounts of those bonds.
what is the value of the vehicle?
The value of the vehicle is $20,500.
And how much is owed?
$22,949.31.
So both bonds are going to be 20,500. The bond they have to pay and the bond you have to pay.
Thank you, Your Honor.
And I don't know where you got this form from. Maybe there's some new law, but this is not what I've seen in the past. So you may want to, I don't know where you need to get a bond that's in the correct form, the order in the correct form. So just get that to me. Rhonda, go ahead. Let me look at this real quick. Yes. Okay. Yeah. Everything's good. Just get that to me as soon as you can.
Will do. Thank you so much, Your Honor.
All right. You have a good rest of your day.
You too. Thank you. Bye-bye.
Walker v. Miwakuda. Plaintiff will be over here, defense will be over. All right, so you heard what I'd said earlier, my court reporter's out today. We can do this on Zoom, in person even if you want to, or we can reschedule the hearing to later today when she gets back. If you want a record.
I'm fine with proceeding on YouTube.
Your Honor, I think we worked most of these out. There's a few things we need the court to kind of set limitations.
Sure,
on.
sure. But do you want to do this now and do it on YouTube and agree to let Tony transcribe it if need be, or do you want to reset or not reset it, but just wait until she gets here? She'll probably get here within the next 2 hours
I'm in favor of just going ahead and doing it.
on YouTube.
Yes.
Okay, let me go ahead and, so let's go on the record, on DC 237918 Walker versus, I'm keep butchering the name. How do you say the last name?
Kuta is what I understand it to be.
Okay, yeah, I guess that's, yeah, okay. So the parties have agreed that, if we need to, the court reporter can transcribe this off of YouTube. Is that correct?
Yes, Judge.
Yes, Your Honor.
All right, let's proceed. I understand there's just a few issues left.
It's defendant's motion.
Yeah, so what do we still have left?
Your Honor, to go to the interrogatories first, number 1 and number 2, we're okay on that.
Okay,
Number 3 requests information on prior accidents that caused injuries, same part of the body over 5 years. Number 4 is to list the healthcare providers.
let me just say on the record, I handle these all exactly the same way in every case. So, and I'm gonna be consistent across the board in every case for prior treatment. I don't care who the lawyers are on either side. I do it the same way in every case, which is you need to provide 5 years worth of treatment to the same areas of the body. For any areas claimed to this. So if there's a neck injury, any prior neck treatment for 5 years prior and anything after the accident to the same areas of the body. That doesn't mean you get into claims information, lawsuits, prior. Let's say she had a lawsuit 4 years ago. Doesn't matter. All I allow it is the treatment. So any treatment 5 years before the accident and post-accident to the same areas of the body. That's what you have to provide.
Thanks, Judge. I
Thank
think that
you, Your Honor.
resolved a lot of the other
Okay,
outstanding.
Yeah, that was the only issue. She wanted 1 year and we wanted 5 years.
but understand you don't get any claims info. You don't get you're not gonna be able to bring up, hey, you filed a claim with Allstate 4 years ago, or you filed a lawsuit 2 years ago. It's just the treatment.
Right.
Yes.
Okay,
Number 5 is simply to identify the primary care physician, and she objected that was duplicative, but I think that would be a total separate issue in case she's
if the
gone.
doctor provided treatment to the same areas of the body within the 5 years prior and anything post, you need to produce it. If they haven't, and you don't need to produce it.
Thank you, Your Honor. Number 6 and number 7 have to do with employment information, earning information for 5 years, and they were not clear when we talked about whether they're requesting loss of earnings.
It depends. If you're not claiming loss of earnings, you don't have to produce that. If you are claiming loss of earnings, you'll have to produce something.
Yeah, so when we spoke with the opposing counsel, our position was that nothing in our petition or anything like that was requesting or claiming loss of earning capacity. So these requests are irrelevant.
So you're not claiming loss of earnings. Okay.
As long as that's clear, I'm all right. Number 10 is taken care of by request for admission. Number 9 is the same issue.
Mr. Anderson, I'm sorry, your piece of paper there is, yes, move your piece of paper up.
Oh, I see. I'm sorry.
Sorry, it was just,
Judge, I'm getting a little hard of hearing just recently.
I'll try to speak a little louder. I'm so sorry.
Thank you. Number 9, identify past injuries, worker comp and disability claims. We asked for 10 years. On that is 5 years.
5 years, same area of the body, treatment only, so you don't get the claims. But if you have, like, say, for example, you can't get the medicals except for by getting the claims, then you can get say there's a workers' comp file, you can get the workers' comp file, you're not gonna be able to argue that she made a claim under workers' comp, but if there's treatment within the file, you can use that to cross-examine her.
Thank you, Your Honor. Number 11 is the same issue again. She wants 1 year and we want 5 years. That has to do with time and place of all prior slip and fall accidents, workers' comp claims, or,
5 years of treatment.
thank you, Your Honor. Number 12 is just asking to identify anyone the plaintiff spoke to at the scene and just the substance of the conversations.
That is, yeah, I'm gonna allow them.
I thought we agreed on that one, that we would supplement.
Yeah, they,
I have in my notes.
yeah, she'll need to supplement that.
Who she spoke to, you guys limited to who she spoke to.
I'm sorry, I'm having trouble hearing you now.
It's okay, but we agreed on that one. We don't have to go.
Okay, good, good.
All right, thank you. Number 13, I think, was again, just, we wanted 5 years. She wants to limit, I'll agree to this, that she wants to limit claims, prior lawsuits for injury lawsuits only. I can agree to that if we can agree on the time.
Our position is the way it's written is that identify every lawsuit in the past 5 years. So I didn't find that to be relevant, Judge.
Okay.
5 years worth of treatment, no lawsuits, no claims, 5 years of treatment.
So she doesn't have to identify claims, only. the
No,
treatment.
only unless they treated, unless she treated. The only way that comes up is if she doesn't remember the doctor's name, but she knows she filed the claim, then you'd have to produce that. But it's only for the same areas of the body and not for any, she doesn't have to produce any lawsuit information.
Thank you, Your Honor. 14 and 15, I believe we worked out an agreement on those. On the request for admissions, number 3, we asked for 10 years, and I think had to do with injuries in the last 10 years, and I think she wanted less time.
We could do 5, but we thought 10 years was way too broad.
Yeah, 5 years, same areas of the body, same thing.
Okay. Then admission number 5 is same thing again. We asked for 10 years regarding prior injuries and non-motor vehicle accidents.
How is this an admission? I'm not sure. I guess I don't know how it's worded.
Just to admit or deny that she had had prior injuries from non-motor vehicle accidents in the last 10 years.
And you objected to that?
We objected, and then notwithstanding the objection, we denied.
Yeah, so I don't even think that's appropriate request for admission, so I'll sustain the objection.
Number 6, again, gets back to felony convictions in the last 10 years. I think we've agreed. We've got a ruling on the request for interrogatories on that same issue.
Yeah, I'm gonna require, if they have any, she has any convictions in the last 10 years, either the same area, if she has any felony convictions or crimes of moral turpitude in the last 10 years, then that would need to be produced.
And number 7 is, we asked to admit that she still has a pending lawsuit, which is kind of general, but I think, if she has something pending that's injury related, we're entitled to a response to that.
Did you object to that?
And we objected.
Sustained.
Thanks.
I think the rest of the admissions are okay, Your Honor.
Perfect. Anything else, guys?
This is your motion.
Yeah, 10 through 15, no problem. Number 9 may have had to do with the 5 years or 1 year again. Had prior injuries to the same body parts.
Is that a request for admission?
Yes.
I'm gonna sustain the objection. I don't think that's appropriate for an request for. I don't think that's appropriate for a request for admission.
On the request for production, 1 and 2 are okay. Number 3, we just asked for any documents if she's requesting a diminished value on the vehicle, what she would base the value on that.
Are you making a claim for diminished value on the vehicle?
We are, but council, we worked that one out. Actually, the Friday before our last hearing, we supplemented and we provided you the repair request, the repair invoice. Remember we talked about it?
No, I don't remember that one, but some of the things y'all supplemented didn't come through, so I'll have to.
I will say this for diminished value. Sometimes there is additional information that needs to be provided. So if there is anything beyond the repair estimates that you're trying to claim under diminished value, you would need to produce those as well.
Yeah, so today we produced everything we had.
Okay, well, if there's something I'm going to overrule any objection. You're to provide any information that you're intending to use at trial on diminished value. And if it's just the repairs, that's fine. But sometimes people do other things with that. And so I'm going to overrule that objection. You're required to produce all of it if there's anything else.
Request number 5, we requested her to sign a medical release and she objected to it as being open-ended, and we can't really specify where we're asking to be released until we get the identity of the doctors, the providers that we ask for in interrogatories. So
You're going to be required to produce a release for 5 years worth of treatment to the same areas of the body.
And thanks, Judge, that was our only concern. It wasn't limited, it was just the release. But can we ask that it be limited to her actual injuries? For example, we don't want them being able to get her gynecological records.
Absolutely.
Okay.
You only need to produce the names of doctors that's treated her for the same areas of the body in the last 5 years. And then, so the way this should work is you provide the names of any, let's say she had a chiropractic visit 3 years prior to the accident, you provide that name, then he's allowed to request those records. But if she went to a gynecologist then and did not treat for her back or neck, then with the gynecologist, you would not need to produce that because it's not treating the same areas of the body.
Your Honor, what if we determined that there was, through the other stuff we get, that there was another accident, say 7 years ago with identical injuries and a disability claim? Can we then?
If it's treatment within 5 years of the accident, let's say she was injured 7 years ago, but she continued to treat for 3 years. So she had treatments within 5 years of the accident, then she would be able to get into it. If it's 6 years ago, 7 years ago, you don't get into it. Anything else, Mr.? We do have a number of hearings, Mr. Anderson. Anything else?
Number 11 request, we asked for anything they have on the defendant's driving record, and they objected to that, and it's just a matter of
Do you have a negligent entrustment claim?
No.
Then you don't need to produce that. If you amend, let me just make it clear, if you amend to include a negligent entrustment claim, you would need to produce that.
It's just that sometimes you get into a deposition and your client hadn't told you about everything and they surprise you with something.
It's not relevant unless there's a negligent entrustment claim.
Okay, number 12, I think we've taken care of medical records for injuries within the last 5 years. Number 15 is if counsel represented her in one of the prior claims were entitled to get medical records, we ask for any medical records in which counsel represented her, because if she would still have those records, that would, for economy and time and savings, she would be able to produce those to us without having to subpoena them.
I agree, but we talked about this and we supplemented. I've never represented this client before, so there's no records to produce.
Okay.
Refresh counsel.
As long as we have that representation.
Yes, no problem.
And I think the other things were still ruled on for the interrogatories. I think that's all we needed today, Judge.
All right. Anything else today?
No,
I do want to talk to y'all about one issue involving this case. You guys are currently set on July 2nd for a non-jury trial. there's a decent chance I will not be in town that week. I usually go with my family for July 4th week. So, and it's a non-jury. If we did do something that week, it would just be non-jury. But 99.9% of my car wreck cases are not non-jury. And so do you want to bump the case back a week to the 9th, July 9th? And are you going to request a jury on this, or have you requested a jury?
I believe we did request a jury trial. a few
I
months
think both
ago.
sides have probably requested a jury, Your Honor.
Let me double check. I'm just telling you what's on the system. You may be absolutely correct. Yeah, Rhonda, it looks like, Rhonda, are you there? Rhonda, are you there?
Yes, I'm
Rhonda,
here.
you're-
Sorry about
okay.
that, Judge, I'm here.
That's okay. So Walker versus Maywood, do you want to move it back a week and make it a jury trial to July 9th?
I think so, Your Honor.
Is that okay with you, Ms. Patrick?
Yes, sir.
All right. The parties have agreed to move this case to July 9th. They double check to see that they've paid to the jury. It looks like they did on the system, but if they have paid it, then go ahead and set it on the jury docket, but move it back to July 9th by agreement.
Got it. Okay.
All right. And send out a new notice. Do you have a mediator on this?
Well, we just agreed to mediate, and we reached out to, I believe, Mr. Berman, but it was through lead counsel Malcolm Rennick that I.
Yeah,
agreed.
Mr. Rennick's in charge of that. I don't know what they've agreed to, but.
Mr. Berman?
Berman is-
Okay, so you'll need to get in a motion, if that's the case, agreed motion to substitute mediators on that. Just make sure you do that.
Sounds good.
Your Honor, can I get a copy of the record that was made here this morning in time to make sure that we're all in compliance?
You'll need to request that from the court reporter. And you can also look at it. If you don't remember what happened, you can watch it on YouTube as well. That would be cheaper than requesting a record. You'd have to pay for a record.
And in
So-
all fairness, we did agree that any supplements plaintiff will make by March 1st, just so it's on the record.
Okay, by March 1st. All right, thank you so much, guys. You have a great rest of your day. It's good to see you both.
Thank you for your time.
No problem. Bodos versus Holiday, if you guys can come on up here. Plaintiff is always on this side, defense is always on that side.
No problem.
Courtesy copy for you, Your Honor, may I approach?
Sure.
Mr. Cobb. Courtesy copy.
Oh.
Thank you.
Okay. All right, so the same issue. Do you guys, if you need a record, we're gonna have to delay this until my court reporter gets here. If we want to do it on YouTube, we can do it on YouTube. What are your thoughts?
I'm okay with doing it on YouTube, Your Honor. Fine, too, Judge.
All right, let's go on the record on DC 21-14477, Colobotus versus Holiday. The counsel and parties make your appearances.
Aaron Gankowski here for defendants, William Chappell, Joshua Ty, and City Realty Alliance LLC.
All right, let's go ahead and proceed. We're here on I believe, a motion for summary judgment, correct?
Yes, Your Honor. It's 3 motions for no evidence summary judgment on all claims that have been alleged by Mr. Calabatos.
Okay,
There was a response or an objection filed. I have filed a response which requests there's objections to the evidence that was presented, and there's an order in the binder that I provided that we can work through. So we would ask those be ruled on before going forward with the no evidence summary judgment.
I'm sorry, are you saying, I want to make sure I understand what you're saying. So you saying you filed objection to his evidence,
No,
or
no, no.
he filed objections to your evidence?
He filed something called objection to motion for summary judgment. which was filed on the deadline for responding to the summary judgment.
Okay,
And then in that objection, there's a bunch of evidence, but I'm objecting to any of the a majority of the evidence because there are evidentiary issues with.
okay.
And so I don't know if that was meant as a response to the summary judgment or if it's a separate issue, but from my understanding, it looks like it is a response to the summary.
Was that meant to be a response to the summary judgment?
Judge, I combined the response and the objection.
Okay,
You're absolutely right. It was, I've been a little bit difficult and challenging at this point in this case to try to get an attorney. So I've had to rely on the law library, and I'm not an attorney and a psychologist, so it's been a little bit challenging, Your Honor.
sure, no problem. All right, so,
The first red tab, Your Honor, is the objection. So if we want to go to that first, we can just start with that.
okay, so I'm looking at your order you produced, order on the evidentiary objections of defendants William Chappell, Joshua Ty, and Citywide Alliance Realty.
Yes, Your Honor.
Okay, and then it says objection, page 1, March 2022. So are you objecting to essentially his timeline?
In the motion, which is the first document that's in the binder, Your Honor, it actually lays out what it is. But on the first issue, I'll give you the page number for where it starts. On page 10 of the first set of motions, it actually lays out what our arguments are for excluding this information.
All right. I'm just trying to find out what exactly you're objecting to. But
Sure,
let me double check.
there isn't paragraph numbers, Your Honor, so it's a little bit difficult for me to.
Okay.
So I just had to identify it by the best I could.
I see. Okay. That's helpful. All right. Let me just go through these real quick. First objection is sustained. Second objection. Sustained. Third objection is
On the first, like in the first document on page 10. So if you look at the bottom, there's the page.
sustained. Fourth one. Sustained. Fifth one. Sustained. Sixth one. Sixth objection is overruled. Or denied, I guess. So the next objection, which is page 6, paragraph 1.3. What is exhibit D? Is that an affidavit or is that?
No, there is no affidavit, Your Honor, that was included. It was, so that if you look at the last set, there's one that's called a second supplement to plaintiff's fourth amended petition, which looked like an affidavit, but it was filed the day after the deadline for filing, which is the affidavit that's, I guess, is supposed to support the entire motion, but it doesn't cite to any of the evidence and it doesn't actually have anything to do with my clients. So
So let me just, so there's, you say lack of foundation, the property is over $70,000 of undisclosed repairs, including a 5-foot crack in the back of the property. The required demolition has been and was hidden by a burlap carpet and a leaning retaining wall that was hidden by overgrown bushes. Was that statement supported by an affidavit?
that was untimely filed, yes, Your Honor.
And that was in the affidavit?
Correct.
Right, I'll deny that objection then. Then the next one is these defects were pointed out within days after plaintiff took, is that supported by an affidavit?
No, Your Honor, it's supported by an unsubstantiated document that hasn't been produced to us, nor was it referenced in the affidavit provided by Mr. Calvatos.
So the statement he's objecting to is these defects were pointed out within days after plaintiff took possession and a certified letter was sent to defendant Holiday. did you have an affidavit that supported that
I
statement?
did, Judge.
What-
In my affidavit, it mentions that, and I sent.
When was this affidavit filed that we're talking about?
It was filed the day after the deadline, so, let me look, Your Honor. Because I believe,
16th.
yeah.
Of February, Judge.
and so it was due on the 15th, Your Honor, and
Let
So
me,
one day late.
let me look at it real quick.
I might also mention, Your Honor, that it's not actually explicitly referenced in the response at all either. It's not cited to, it's not.
It's point number 7, Judge, on the affidavit, on the second page of the affidavit.
I apologize. I need to get to the affidavit. Give me one second.
Did you want me to approach and give you a copy, Judge?
Is it in this
It
notebook?
is in the notebook, Your Honor.
You,
It is,
you color coded this in kind of a little bit confusing way.
I
so-
apologize, Your Honor. So, it is, I believe, the green tab.
Green tab, okay?
So it is just called second supplement plaintiff's fourth amended original
Okay.
petition, and then it just at the top.
I see it, okay. All right, he supported that with an affidavit, so that's the 9. All right, there's nothing to support. It looks like the claim, really, this is just argument to me, sorry, this is very hard to follow. So the statement where there's no admissible evidence supports the claim the plaintiff has over $70,000 of undisclosed repairs. Where does that come from, that statement?
It comes from that page 6, 1.3 of the of plaintiff's objection response. I assume that it's supposed to be supported by some unsubstantiated invoices that are in there or estimates, but again, there's nothing I don't believe that they're even referenced in the affidavit.
I'll just say this order is not going to be super clear because there's so many objections that say objection page 6.1.3 without any substantiation.
I understand, Your Honor. It's just, if you look at it's hard to be able to just drop all that, the motions all the time, so.
Okay. All right, I'll sustain that objection, and then the objection is, in Texas, a real estate agent is required to disclose all material facts. What is Exhibit G?
Moment here, Honor.
Where can I find it in the binder?
It would be under the red tab, and then it is, they're not numbered, Your Honor, but it looks like it's about 15 pages in. It's a thing called loss history report details.
That it's the red.
Yeah, so the first red tab about, I'll give you the exact
Oh,
one.
there's 2 red tabs. Is the first red tab?
The first red tab, yes, Your Honor.
Okay, and you said it's
about
I see Exhibit G now, okay.
Oh.
So, this is the loss history report details.
Judge, that was given to me by the insurance company because I had a lot of,
Your Honor, I'm gonna object to that statement. It wasn't in the evidence, it wasn't.
Well, just let him finish.
thank you, Judge.
Yeah.
It was I wasn't able to get insurance when I bought the property, Judge, and I didn't know why. And when they gave me insurance, it was exorbitant. I said, why is it so expensive? It was like 6,000-7,000, Judge, for a $250,000 coverage. And they said, oh, because of the claims you filed. I said, I've never filed a claim. Yes, you have. You filed 2 claims. I said, not me. Oh, they said, well, the claims follow the owner. So the property, if it's the previous owner and he's filed claims, it'll follow the property. So it'll hit the person that buys it and the other person that buys it.
So what I'm trying to get at, and I appreciate that background. What I'm trying to get at is this exhibit G, it doesn't really say. So this is something provided to you by the insurance company.
It is, Judge.
But is there anything that, I mean, you've been in a lot of litigation, Mr. Klopotos. I've seen you many times. So is there anything that you have to have an affidavit to prove up evidence in a summary judgment for most evidence? And so unless it's like depositions and things like that, or it's self-authenticating, what proves up this document? Do you have an affidavit? Do you have what objection to hearsay are you making? What exception to hearsay are you arguing would allow the admission of this exhibit?
The fraud, the non-disclosure, Judge, because under Texas property.
All right, that's denied. Okay, so I'm sorry, that objection is sustained. Let's go to objection page 23.
Let me find that one for you, Your Honor, because it's not clear.
Okay, that's not an evidentiary objection. I'm going to deny that one. Page 24. Overrule, that's denied. Page, I guess there's 2 objections on page 24. That's sustained. Settlement discussions don't come in. All right. Exhibit C is denied. Objections denied. D. Is there anything so I guess exhibit D is photos, is that correct?
It is, Judge. It's the 5-foot crack.
Do you
In the back of the house.
do you have anywhere in your, usually photographs need to be authenticated? Do you in your affidavit state that these are photographs that you took or when they were taken or anything like that, or approximately when they were taken?
No, Judge, but I have in the contractor's estimate that I got at the time of purchase or after that I closed on the property, that substantiates the fact there's a retaining wall issue and a foundation problem.
Right, I'll sustain the objection to exhibit D. Exhibit E. What is exhibit E?
It's the certified letter that he sent to Mr. Holliday. It is not addressed to my clients. We would have it doesn't have any bearing on our liability. We never received this letter. This never wasn't sent to us. It's doesn't mention us. There's nothing about it that's going to be influential on this.
Judge, that's part of the disclosure. Had his clients disclosed these defects in the property, I mean, his clients knew about it. Had they disclosed it, had they given me a disclosure like it's mentioned in the Texas Property Code 5.008, we wouldn't even be here, Your Honor. So his fact that the broker And the real estate agent made a mention of $70,000 worth of repairs.
I'm gonna deny this objection. What is exhibit F? Let me see.
It's a document that Mr. Calabatos appears to have drafted himself. It's an assignment of the claims from Marvel Incorporated to him. But you had already dismissed those for want of prosecution. And I think that he's trying to get around your dismissal order to be able to revive those claims. So I don't really know why that's relevant, nor if it's appropriate at all. And if you look at the briefing, I don't believe it is appropriate. I think that it violates all of the rules about assignment of claims. So I think it needs to be excluded.
Your Honor, it is my attempt because Marvel Investments can't really represent themselves, which is why I assigned the claims, and I have the intention of reviving that because I think it was dismissed because the attorney didn't show up for the hearing.
All right, F is the objection sustained. G.
That's that loss history report, Your Honor.
G, the objection is denied. Fourth supplement. So are you okay, this isn't an evidentiary objection.
This is a separate objection, Your Honor. This is, it appears to be a trial or an amendment to the petition.
The next two, I'm not gonna rule on it as part of these objections. You can argue it. All right, let's go to the argument now in the case.
All right, Your Honor. Based off of the evidence that was produced and anything that has been left in the court's record at this point, my clients aren't mentioned once in any of these documents. There's no evidence tying them. Mr. Calabatos' affidavit doesn't talk about them. There's nothing in the entire response that mentions my client. So at this point, I believe that there is no evidence of any of the claims that Mr. Calabatos is trying to make. And then if you look at the claim that he's talking about, I lay it out in my argument in the document that I've produced, or that 5.08, it has some very specific language. It talks about the seller is required to do this. And then the legislature in 2 paragraphs later, I believe that the first paragraph that we're referencing to is 5.008 or 088. And in that C, and that's the section about seller disclosures. And then if you go down to, I believe it's E, it specifically says seller and seller's agent are not required to disclose these things. So if the legislature had wanted to impose liability on the broker and the real estate agent in this circumstances, they would have used that language because they used it previously on this situation. Additionally, it allows for, if you look later on in that section on 5.008, if you look at that, it says that if you don't have knowledge of those defects, then you don't have to disclose them, or you can just say unknown, which my clients didn't own the property, had no interest in the property, didn't live in the property. There's no way they would have known about these defects, which if you look at the affidavit of Mr. Calabatos, says that the big crack that he's complaining of was hidden under a burlap rug. Then there was a leaning retaining wall that was hidden by bushes. And then there's also this undisclosed these undisclosed insurance claims, but my client wouldn't know about any of that information. So if they had filled out, even if they had filled out this information, it wouldn't have been any more beneficial to Mr. Calabatos because they would have just said unknown.
Okay, response?
Judge, I think the Texas Property Code actually mentions, and they're very strict about real estate agents and brokers. They actually have to give a disclosure form. It says seller's disclosure of property condition in Texas, the seller of residential property not comprising more than 1 unit dwelling shall give to the purchaser of the property a written notice. The notice must be executed and must at a minimum read substantially similar to the following. Seller's disclosure notice concerning the property. He must provide previous inspection reports. He must provide the condition or presence, absence of appliances equipment, and fixtures. He must report on the condition of the driveways, entrance, walkways. The notice shall be completed to the best of the seller and the agent. The seller's disclosure requirements do not apply to foreclosure sales. The seller can be responsible, in addition to the broker or the agent, for a penalty of $10,000 and up to 3 times the damages. Licensees such as real estate agents, companies have a duty to disclose to any potential buyer or purchaser any significant defects that they know about the property, even if the seller does not disclose that information. They also mentioned that if the seller doesn't disclose, Your Honor, that the agent has to take extra steps, saying that he has to sign some sort of document that says that he did his due diligence, he's asked, but the seller didn't want to provide. He can't just say, oh, I didn't know about it. He can't feign ignorance, Your Honor. He has to take that extra step if the seller does not disclose these defects. Your Honor, on the certified letter that I sent to Mr. Holliday, that was discovered days after I took possession. And I sent it to him. And in my affidavit, when I called him 2 weeks later, I said, Mr. Holliday, what are you going to do about these repairs? He says, you bought the property, now deal with it. So that's all in my affidavit, Judge. If you look at the date of the certified letter, it was days, Your Honor, after I took possession. I think 2 days, because then I was able, that property was vacant, Judge. And he was on a doctor's appointment. Mr. Holliday was ill and he passed on. They didn't even disclose that, Judge. They didn't disclose. He passed on, who knows, was it in August, September? But I filed a fascia sire in November, December of just this year, Judge, 7-8 months. The Mr. Sibley, the Holiday's attorney didn't say, oh, Your Honor, let's put you on notice that, Mr. Holliday has passed. So
This isn't a summary judgment by Holiday, right?
no, this is by Chappell, but Chappell is still held responsible, Judge. A seller's property disclosure is governed by state and federal laws. Both the seller and the buyer will sign the disclosure form as proof that it has been given and received. Sellers, real estate agents, brokers must disclose any defects or hazards of the properties. So if he didn't disclose because he didn't know, he should have done a walkthrough, Judge. He must have known. One of the problems was the front door, Judge. The front door. Mr. Holliday opened the door for me, so I had no clue. But you can lock the front door, Judge, if there was a strong wind.
There was no inspection on this?
There was not, Judge, and I understand now why. I mean, when I went to the property, Mr. Holliday had moved out. He had moved to Frisco. So I guess he was paying.
Your Honor, I'm going to object to this. This is testimony by the plaintiff, and there's none of this is in the record. None of this is before the court. I don't know. Honestly, even the information that he read about the seller's disclosure, it doesn't match up with the information that is in those statutes. So the thing is, I don't know if he's pulling that from a treatise or what. It's not in his briefing. It's at best, it's in that supplemental, but there's no cites in that. The only thing that it cites to is the 5.008 or 88 of the Texas Property Code. I can't respond to that. So I'd request that it be stricken from the record.
Judge, it's also in the TAR disclosure notice form. It's everywhere that the buyer has to receive a disclosure form. It says that a common mistake made by agents under the TAR disclosure form is making a decision that a disclosures notice is not required to participate in a particular transaction. It's a common misconception that the belief of notice is not required. An administration of an estate or okay, that's defendants. There is, Judge, Schroyer versus McNeil, 323 Maryland 275-283.
Your Honor, I believe
Says that the real estate agent must disclose, Judge. It's written everywhere. I mean, you can go to the law library and I just put disclosure. Oh my God, there's tons of information comes up. He's trying, Your Honor, to absolve himself from the responsibility of his right. He is, and the broker is, Your Honor, because they are liable. It says it everywhere. They should have given me a disclosure and we wouldn't even be here. I would have said, oh no, Mr. Holliday, too many things, or knock the price down 75,000 off the repairs. No, I asked him, Judge, and it's in my affidavit. I said, do you have any problems with foundation? No, no. Do you have any problem with electricity? Just the basic stuff. I mean, paint, I'm not gonna ask, I can see it. But just the basic stuff, hidden stuff, Judge. But I guess the property needed to be sold. And now I know, Your Honor, why he offered me owner financing. Because I think that property was attempted to be bought by somebody else. And I guess they went through traditional, but he says, I can offer you financing. Really? And I paid down, I think, $35,000 down, and he offered me financing. But I mean, we're talking about Chapel and Ty. They did have a responsibility. I don't want to get off the topic, Judge, and I have a habit of doing that. I'm sorry.
Your Honor,
But they had a responsibility.
All right, the response.
Your Honor, I'm gonna just object to this. It's again, the plaintiff is just providing testimony in open court that isn't in any of the documents that he's provided. Like I said, there is nothing that ties my clients to this. There's no contract. There's no reference to them in any of the documents. There's not anything that links them to this. So the thing is, I can't speak to that. Now, on the stuff he's citing to a Maryland case. I'm believing that he's reading from a treatise that is a national treatise and not a Texas specific treatise. And so the thing is, I can't verify any of that information because I don't know where it's coming from. I don't know what that case law is, but I do. And I tried to avoid briefing this because I didn't think that it was relevant based on the information that was provided. But the problem is that the real estate contract merges into the deed after sale. And that's just how it goes. So unless there's nothing that ties my client to a non-disclosure in this situation at all. So even with all of this argument that's going on, it's not going to provide anything for the court to be able to allow this case to continue.
Judge, there is in my petition, in my Fourth Amendment petition, it brings his clients into it. That's why his clients were brought in to begin with, Judge. It's fraud by non-representation or non-disclosure. So in the Fourth Amended petition, Your Honor, I brought his clients in because of that. And it actually, there's.
Mr. Colabotos, I've tried to be very patient, that based on what you filed and I know it's difficult. You've had a lot of lawsuits. You've been in a lot of litigation. I understand it's hard for you to find a lawyer, and this is a complicated area responding to summary judgment. But based on the record before me, unfortunately, I have to grant the summary judgment. Do you have a proposed order?
I do. It's in the back folder of the binder for you, Your Honor.
So I want to make clear, this is not a final order for the case, correct?
Correct. It says it's interlocutory at the end.
Okay.
Your Honor, there is one other issue that is in that judgment that I do want to make mention of.
What's that?
In the original petition, which is the blue tab, or the Fourth Amendment petition, which is the live pleading, Mr. Colabotos alleges a breach of contract claim. So we had requested attorney's fees under 38.
I'm not going to grant attorney fees at this point until there's a final judgment.
Okay.
I'm crossing out the paragraph about that.
Thank you, Your Honor.
All right. You guys have a great rest of your day.
Thank you.
And we'll go ahead. Can you take these orders back to Rhonda? Okay, it's been a busy morning, guys. Let's go to NRA. DC 24816. Anyone here in that case? Okay.
AG Wentworth.
All right, we're gonna go off the YouTube on this. This isn't something that we put on YouTube.